I want to thank the Colleton County Clerk of Court, Becky Hill, and her entire team and their staff. I don't know. I call her Becky Booth. That's her nickname. But Madam Clerk, wherever you are tonight, I'm sorry. That's my pet name for her.
An update on a continuing story that's probably going to be with us for a while. I'm talking about the accusations Alex Murdaugh's attorneys made against the clerk of court, Becky Hill.
The clerk of court had improper private communications with the jurors, and the subject matter of those communications was the credibility of the defense that the Murdaugh legal defense team put up, and it was the believability of the defendant's own testimony.
So far, Becky has not given any comments about the accusations.
Any comments at all about the allegations? Did you tamper with the jurors? Do you have lawyers now? Any comment at all, Rebecca? Anything?
Although Becky is not talking, her co-author has stepped out to give her support.
I got to tell you, you asked my reaction. I was pretty upset at what Harpootlian said was the motivation that Becky had. Last time I checked, Simon & Schuster did not send us a check for $200,000. The Gordons and the Hills put up $30,000 of our own money because we felt this was an interesting story to tell. So right away, Vinny, for that to be motivation for her to get a book deal is completely false. We felt it was a story that should be told. I mean, in my lifetime, I'm 59 years old. I don't know that there will ever be another trial like this. And it was my honor and pleasure to work with somebody with such integrity and character as someone like Becky Hill.
Becky has now hired attorney Justin Bamberg. I've mentioned him here several times. He's the attorney for quite a few of Alex's financial victims, including Miss Pamela Pinckney, Arthur Badger, and a few others. He also appeared on the 2022 documentary about the Murdaughs on HBO Max, Low Country. Attorney Eric Bland also gave comment that if these accusations are not proven, he believes that Becky Hill has a colossal defamation suit against Dick and Jim, as seen here on two different interviews, one with Court TV and one with News Nation.
But again, this is very serious, and Harpootlian is going after the king, and you better kill the king when you go after him, because if not, Becky Hill's going to have the best defamation case I have ever seen against Dick Harpootlian. And remember, when you go for the king, you better hit the king and you better kill the king. If Dick does not score on this, because there could be 10 jurors, Chris, that are going to come in and say that didn't happen, Becky Hill's going to have the greatest defamation claim against Dick Harpootlian that the legal world has ever seen.
Did Becky do something ethically wrong by writing her book? It seems she wrote and asked permission first. Good morning, Courtney. My name is Rebecca Hill, and I'm the clerk of court in Colleton County. I have a question about the writing of a book by a clerk of court about the process of trial from beginning to end, focusing on the process itself, the history of it, and of course, the high-profile cases that South Carolina has had. What would be the ethic procedures behind this? And received this answer. 1. Does the opportunity for the activity arise as a result of your position as clerk of court? 2. Is the subject matter of the work something within your official responsibility? Is this type of work something that the clerk of court's office would normally perform and for which you could receive expense reimbursement for by the clerk of court's office? If the answers to all of these questions are yes, then writing the book would be within your official capacity and it would be impermissible for you to receive compensation for writing the book. In the opinion of commission staff, it seems unlikely that writing a book would fall within your official responsibilities as clerk of court. However, you will have to make the ultimate determination based on your official duties and the guidelines offered above. If the answer to any of the above questions is no, then the work is not within your official capacity, and you may receive compensation for authoring the book so long as you adhere to the Commission's guidelines on off-duty employment. What bothers me here so much is that she omitted a lot of information, and I won't say outright lied, but didn't tell the truth. She said her book would be about the process of trial from beginning to end, focusing on the process itself, the history of it, and of course, high-profile cases, plural, that South Carolina has had. This is not what her book was about. Her book was about her role as clerk of court in a specific case. Just look at the cover and the title of the book. So, I don't know if she had put the correct information, what her answer would have been in that case, but to me, this is not just suspicious. But what irks me the most of this whole thing is how it puts into possible jeopardy such a large case that was so expensive to a county that's already enduring economic hardship. It's also her book tour.
The court does a big job of being a liaison between the judge, the lawyers, the public, the documents that are in a trial. In a case of this magnitude, there's a lot of documents, there's a lot of paper, there was a lot of people that had come together from all over the world. We had people coming from France, England, California, Wyoming, and so many other places, just to be able to open our doors and have everything together for the trial that we were going to have. Just a normal, any other day kind of trial was huge. It was epic.
It's also things she said about who she's gotten to meet and autographing and the self-glorification that comes before the thoughts of what this might do to all of the people who worked very, very hard on this case and all of the tax dollars that went towards this case. So whether or not she did the things she's been accused of, the things that she did in fact do that we know for sure, put this case in extreme jeopardy. And that's what bothers me. It appears she didn't do anything wrong technically. However, could the book be a problem? A problem big enough to lead to a mistrial?
When the clerk of court wrote her book, published her book, that zone of silence collapsed. Jurors who obviously were not comfortable with how she handled matters were even less comfortable with her going on a book tour and making money off what she did. That's what was reported to us.
There also appears to have been things she wrote about that opened her up to these allegations. Most notably, the Moselle visit.
Joe, did you notice anything yourself? Did you hear things? Because it seems like Dick Harpootlian did, and this is the result.
Vinny, I was there every day for 6 weeks. I watched the jury's faces. I watched the process. I did only hear after the jury visit to Moselle that there were some questionable conversations. I didn't get any more information about that. I obviously was not there, so I didn't know anything about that.
Wait, let me follow up on that 1 second. So conversations at the Moselle property?
Some kind of interaction between, all I heard through that proverbial grapevine is there were some conversations between court officials and jurors as they moved about. Well, that was a kind of a logistical nightmare. They wanted to protect the jury from outside influence. They took them there in a van. They allowed them to walk freely. The interaction of court officials with them to say, do you need to go to the bathroom perhaps, or do you want to walk over here? I mean, I didn't have any problem with that particularly, and what I heard through that grapevine was hardly a smoking gun.
How does it look to play out with the rest of the jury? We don't know, but so far 2 jurors have taken Eric up on his offer to represent. He posted this publicly to let jurors know that he would represent them without cost. The 2 that have taken him up on it have an opposite story to tell. So it depends on the rest of the jury, who will most likely be asked at the very least to give a sworn statement and/or appear in court to give testimony. After hearing there are 2 jurors already contradicting the testimony of these statements, I'm hopeful that this will go well and the verdict will stand.
So, Eric, do you believe, you're representing jurors now, do you believe all the jurors will have the same testimony if they were subpoenaed or had to appear inside the courtroom to talk about any interaction or any observations of the court clerk, Becky Hill? Do you think all the jurors will be in the same boat and say, yeah, X, Y, and Z happened?
No. I can't reveal attorney-client privilege. I represent 2 jurors, but I am pretty sure that what you're going to hear from some of the jurors, if not most of the jurors, except the ones that Joe is representing, it is directly the opposite of what Dick Harpootlian said from the microphone on Tuesday. You know, Vinny, no matter how many times you say something or how loud you say something, doesn't make it true if it's not true. And the fact that there are 1 or 2 jurors that say Ms. Hill said some things before Alex testified or allegedly made some comments about the defense attorneys is troubling. No question it should be investigated. We can never have a situation where anybody other than the judge gives instructions to the jury. But don't be fooled here. You know, these are jurors that sat for 7 weeks and listened to the evidence. If an innocuous statement was made or some kind of offhanded comment, I am certain that 12 jurors would not have given somebody a conviction of murder and ultimately a life sentence simply because of one thing that was said when they heard evidence for 7 weeks and they saw people testify.
If we've got jurors who see or hear things differently and we've got some level of a split inside this jury room, Joe, what does that mean?
Well, I'm not happy to be in the position I am representing 2 jurors. I was asked by the jurors originally to keep the press away from them. Things happened. I can't go into those things, but their decision to give information under oath now is a part of a record that will have to be evaluated.
Your clients, they are the ones who signed these affidavits? Is it their sworn statement or is it the sworn statement of someone they spoke to?
To my knowledge, 2 of the sworn statements by jurors are the jurors that I represent. They came forward reluctantly. They provided their truth. And now that becomes a part of a record that must be evaluated by the court.
I think just because you say it over and over again and you may say it loud doesn't make it true. I don't believe anybody has said to date, even those jurors that gave affidavits, that they were coerced. I don't think anybody said that their jury verdict was the product of coercion or duress. In fact, I don't want to have a system where jurors make a decision, then are individually polled and say that they have given a true and just verdict. And then 3 months later, they start to say, well, maybe I have second thoughts or something happened. And then all of a sudden they flip. We can't have a system like that. Without revealing attorney-client privilege, I believe that my clients, when the time comes for them to be under oath, if they're going to be under oath, I think they're going to tell a different story than what was told by the microphone by Dick Harpootlian.
Truly, we can't have takebacks in this very important process. So what are the allegations actually so far? It sounds like the egg juror was upset at being excused. When she was interviewed initially, she mentioned being disappointed in a different case that she had been selected in to be a juror. It got settled. Maybe she's bitter at the removal of this big case as a juror? If she was upset over the last one, imagine being upset over being removed from a case this big. Dick and Jim also made mention of this Facebook post, but the Facebook post was not the reason for her removal. There were allegations about her speaking to her tenants who spoke on it at work. Was Judge Newman supposed to ignore these allegations or waste even more time running it all down beyond what he did of having SLED look into it? All of this in the middle of a huge trial? No, she was a replaceable part of the process, and the court was right to excuse her, in my opinion. The second juror that's on record seems to be most upset about not being allowed smoke breaks.
The allegation that they were not entitled to given a cigarette break, Chris, that's a privilege. That's not a right. Nobody has a right to a cigarette break during deliberations. It's a common courtesy that some courts do. In New York, they don't do it. In Philadelphia, they don't do it, but maybe once a day. But you don't have a right during deliberations to get a cigarette break. And Dick made a big issue of that.
I'm sorry, but a person's addiction cannot be in the court's consideration. Bring nicotine gum, wear a patch, but you can't expect the legal process to give your addiction special consideration. Are we going to do that for any other addiction the jurors might have? This, in my opinion, is simply not reason enough to overturn a verdict. Eric points out further ways that Dick and Jim overstepped during their press conference.
I am concerned that the process here may be affected by what Harpootlian did at that press conference. One, he made an allegation against the judge that I think was telegraphed, that the judge Newman cannot be the one to hear this if the appellate court reverses and brings it back for a hearing, because he said he was a witness. He's just made Judge Newman a witness, and Judge Newman may not be able to hear it. There's a number of things that Dick said that troubled me, and I don't think at this time that there is a situation where we have jurors that are in agreement. We have jurors that are in disagreement. I do agree that there has to be an investigation. I do agree it needs to be looked into. But what do we do, Chris, if 10 jurors say it didn't happen and 2 say it did? I don't think that's enough to overturn it.
In conclusion, Eric summarized, I think, something that most of us are feeling right now.
I would have preferred that she would have waited until the appeal was over. You never know with these cases. Obviously, the 404B character evidence was a hotly contested issue, which is going to be up on appeal, and there is a possibility that it could be reversed. And so I would have preferred that the court officials would have waited to, write a book. I'm certainly going to be waiting to hear what happens with Judge Newman if there's a retrial. Was his interview that he gave to the Today Show something that could disqualify him? So, I think Joe and I are in agreement on that everybody should have waited, that are clearly elected officials or court personnel, people like Joe or me or anybody else. No, we can write a book, but, people who are on the government payroll, it's a different story. So I would have preferred she waited.
Did she have the right to write this book and capitalize on the moment to enjoy this book tour and all the celebrity that came with it? Apparently. Was it a selfish move that put so much in jeopardy? In my opinion, a strong yes. After this, many more people will know her name. Be careful what you wish for. This is Cassidy O'Connell saying stay well and stay tuned.